Dear students, this is Hari Naganand Idumudi, English Shorthand Instructor. To get updates with regard to our channel, please subscribe our channel. Our channel name is Shorthand Hub for General and Legal Dictations. If you want to join in my WhatsApp group, please send a message to 970 44 55 002. Ready? Start. Dissatisfied with the quantum of compensation of rupees 15,000 out of the total claim of rupees 1 lakh by the award dated 9/11/2005 passed in OP 2822 of 2002 by the Chairman Motor Vehicles Claim Tribunal cum 10th Additional Chief Judge Bombay. The claimant is before this court as appellant. The facts of occurrence of road accident on 28/10/1997 and the claimant sustaining injuries in the said accident are not in dispute. The claimant is only seeking enhancement of compensation in this appeal. During hearing, Land Council for the appellant claimant submits that the claim of rupees 1 lakh itself is meager and granting compensation of rupees 15,000 by the tribunal is on lower side. He further submits that the tribunal hasn't granted any compensation towards the injuries suffered by the claimant, though the tribunal has accepted the evidence of the claimant who deposed as PW1 with regard to the injuries sustained by him. Further, the tribunal granted meager compensation towards pain and suffering, medical expenses, transport expenses, and extra nourishment, and therefore prays to enhance the same. Land Council for the respondents supported the order of the tribunal in all respects and contended that the tribunal, after consideration of the material produced before it, granted rupees 15,000 towards compensation, which is reasonable, and prayed to dismiss the appeal. In view of the above rival contentions, the point that arise for determination in this appeal is whether the compensation awarded by the tribunal is just and reasonable in the facts and circumstances of the case, or whether the same is required to be enhanced. As already stated, supra, the occurrence of the accident and the claimant sustaining injuries in the accident are not in dispute, though the claimant contended that he incurred rupees 30,000 towards medical expenses and filed exhibits A7 and A8 bunch of medical bills. The tribunal, while observing that the doctor who treated the claimant was not examined, awarded rupees 5,000 towards medical expenses. As rightly observed by the tribunal, Since the doctor who treated the claimant was not examined, the tribunal rightly awarded an amount of rupees 5,000 towards medical expenses, and there is nothing to interfere with the same. As per the material on record, the claimant received 4 injuries. Admittedly, no compensation was granted by the tribunal in respect of the said injuries. Therefore, this court deems it appropriate to award rupees 4,000 to each injury. Thus, an amount of rupees 16,000 can be granted for the injuries suffered by the claimant. Admittedly, the claimant took treatment in CDR Hospital, Bombay, as an inpatient from 28/10/1997 to 17/11/1997, but the tribunal did not award any compensation under the head loss of earnings on the ground that the petitioner was a student. As per the judgment of the Apex Court in Divisional Manager, United India Insurance Company Limited, even for the persons who are employed in unorganized sector, loss of earnings can be taken as rupees 6,500 per month. Since the petitioner lost 17 days of income, this court deems it appropriate to award an amount of rupees 4,000 towards loss of earnings. The tribunal granted only rupees 5,000 towards extra nourishment, though the petitioner is said to have been admitted in the hospital and took treatment for 18 days as inpatient.